My name is Patrick Parkinson. I'm the Dean of Law at the University of Queensland. Let me begin on behalf of Caxton Legal Centre and the University of Queensland to acknowledge the traditional owners of the land, the Yagara and Turrbal peoples, the traditional custodians of this land on which we work. We recognise that there are people joining in tonight from other parts of Australia and that there'll be other traditional owners of the land on which you are placed. We want to recognise the ongoing connection of them to the land, waters and community, and to pay our respects to elders past, present and emerging. We also recognise, respect and celebrate the cultural distinctions of the First Nations peoples and value their rich and positive contribution to Queensland and to broader Australian society. And with respect, we strive to achieve justice and inclusion for Aboriginal and Torres Strait Islander peoples. I'm really delighted to be able to welcome you to this seminar, this webinar at least, knowing that it'd be so much nicer if we could be together face to face, but there are corresponding advantages of being able to just to join in from home or our office without all the travel which is involved. It's a really important issue that we're talking about tonight, the issue of restrictive practices and human rights. I've been involved for 35 years now in child protection, family law, and have come across these issues myself when I was chair of the Council to Reform New South Wales child protection law back in the 1990s. One of the very difficult issues we had was what to do about secure care. Young people in care, in desperate situations, suicidal or very violent, and great arguments that we had about whether it was appropriate, and if so, in what circumstances, to impose restrictions, which meant locking them up effectively for a period of time. And we came up with a solution which we thought balanced those different interests, but others had very strongly held different views. This is just one of many examples of where difficult questions have to be faced. And I'm just delighted that such a well-respected panel has come together tonight to discuss these issues. And I'd like now, if I may, to hand over to Karen Williams, who's the principal of ADAR Law, and will take it from here and introduce the panel members. But let me say again, welcome and thank you for participating. And I pay particular tribute to my colleague Tamara Walsh, who's been so involved in getting this webinar going. Thank you.
Thank you, Patrick, and your kind introduction. And before I introduce the panel and begin discussions, I'd just like to outline what to expect in this hour-long webinar. Firstly, you'll notice only presenters will be visible and attendees will be in view mode only, and be able to contribute by asking questions, typing in the question and answer box. So now to our panel. As Patrick mentioned, we have Professor Tamara Walsh. Tamara's based in the School of Law, University of Queensland, where her research focuses on the impact of law on vulnerable people. And together with Prisoners Legal Service, Tamara this year has released a report on legal responses to solitary confinement in Queensland. So we look forward to your contribution soon, Tamara. And we also have Marlene Eggert. Marlene is a registered nurse and has worked as a clinician for 30 years in tertiary and primary care community settings as well. Currently, Marlene is the Senior Policy Advisor for Leading Age Services Australia, which is the national association for all providers of aged care across residential, home care and retirement living seniors housing organisations. Also next we have Mark Viney, and Mark has personally witnessed the concerning effects of use of medication while his father was in aged care. And Mark will share his experience of the impact of the use of the medication upon his father and what it was like for him to negotiate change. And also in our top line panel, we have Mary Burgess with us tonight, and Mary is the Public Advocate for Queensland. And as Public Advocate, Mary's championed various systemic issues in the disability, ageing, health, mental health and guardianship sectors. And she's been champion for change and outspoken about the unlawful use of restrictive practices in residential aged care in particular. So before we go to our panel discussion, I want to acknowledge that there's a wide variety of cohorts and sectors that do utilise restrictive practices, and a discussion on human rights is made all the more difficult without unifying national legislation or scheme articulating a national coherent human rights framework. Also, within the hour, we're enabled to concentrate on all the sectors or to cover the field. So due to the expertise of our panellists, we'll focus mainly on prisons and aged care, but there will be other references to other sectors during our discussions. Obviously, the Human Rights Act Queensland's a starting point as a framework, but that is of limited impact in the aged care sector, which has the relatively new Charter of Aged Care Rights, and there was some promising green shoots in the of human rights focus from the Council of Sisting's final submissions to the Aged Care Royal Commission. So I also want to acknowledge people at the centre of this conversation, people who are impacted heavily by the use of restrictive practices, and we'll hear in particular from Mark in a little while. So the first question I'd like to ask, what are the contexts in Australia in which people in closed environments are being further restrained or confined, and what do these practices look like? So first to you, Tamara, if I might have your observations.
Sure. Thank you for the invitation today. I'd just like to start by acknowledging the traditional owners of the land on which we're all meeting, and to recognise that the overrepresentation of Aboriginal people in prison remains a huge problem in Queensland and in Australia overall. And what that means is that Aboriginal people are necessarily more likely to be subjected to the measures that we're going to talk about today. And so it's really important, I think, that we recognise that and the legacy of colonisation that continues, particularly in this space. When it comes to prisons, of course, prisons are inherently restrictive environments. And so the use of restrictive practices can go on almost as a matter of course. So I think what we need to be remembering in this discussion, the context of prison environments, is that it's going to happen, and we need to make sure that the balance is right. So the thing that concerns me as a researcher is that when I do research in this space, I hear that there is a culture of excessive force within prisons, and that's extremely worrying. For example, handcuffs. Handcuffs are an example of physical restraint. They are used often, as you would expect, but they're used in some situations that could be considered inhumane. And I've heard many stories in the course of my research of people being in handcuffs when they're receiving medical treatment. That's inappropriate, and it's an inappropriate use of physical restraint. Chemical restraints. Many people in prisons are subjected to chemical restraint in the form of prescription medications for mental illnesses. Now, again, we would expect that. There's a high rate of mental illness amongst prisoners, but unfortunately what we hear is that often people are prescribed antipsychotic medication in situations where they haven't been diagnosed with a mental health condition, and particularly people with cognitive impairment, intellectual disabilities, and other people who might have disabilities that make them more likely to engage in what we'd consider to be challenging behaviours. Unfortunately, what we find is that these people are sometimes prescribed medications that they don't have a relevant diagnosis for. But as you mentioned earlier, the study that I undertook with Prisons Legal Service this year concerned a very worrying example of restrictive practices being used in prison, that is solitary confinement. And again, the reason why solitary confinement is so concerning is because the people who are placed in solitary confinement are amongst the most vulnerable of all prisoners. So again, people with severe mental health conditions, people with cognitive impairments, people who are actively suicidal. These are the people who we place in solitary confinement cells, and the conditions in those cells are horrific. And when I went into this study, I knew that I was going to be seeing and hearing about some really difficult things, and yet I was shocked even by what I heard. People with no mental stimulation, very limited physical activity, no social contact. And what we found in that research was that people are literally going mad in these solitary confinement cells. So there's many examples of restrictive practices in Queensland prisons and indeed in prisons across Australia. The question is, are we striking the right balance?
Thank you, Tamara. Mary, can you outline the context that you see from your perspective?
Yes, thank you, Karen, and thanks for being here, inviting me to be here this afternoon. And I would also like to acknowledge the traditional owners of the land on which we are all meeting from our different places of linking in. In my role, I have responsibility for people with impaired decision-making capacity, or at least to advocate for them. And that can include people with a mental illness, intellectual disability, an acquired brain injury, and also people with age-related conditions such as dementia. So it covers a wide, I suppose, gamut of sectors. And also you see people with those conditions especially in prison, because prison seems to have been the final safety net for many people in those circumstances, because disadvantage often causes you to push up against the justice system. So, so I have a wide range of interests, and my concern is that we see restrictive practices being used across a lot of sectors. So from residential aged care to mental health facilities and prisons, to disability service and support settings, in supported accommodation for people who may have other disability or other health or mental health conditions, but also in hospital and health facilities. They are being used, and also of course, often unmentioned, but actually Patrick did earlier, in relation to children in educational facilities and detention centres. And in some of these settings, there is some legal framework for it. In many, there is no framework at all. And so essentially these practices are happening in a legal vacuum. It's unclear whether they are lawful. Generally, the use of a restrictive practice is only lawful if it can be defended in terms of emergency. So it's questionable about the legality of the practices, depending on the circumstances and the legal framework that people are operating in. I thought it might be helpful to give a little bit of we talk about restrictive practices, but it's very hard to get people to settle on a definition, and I'm not going to say the definition I'm going to give is the definition, but it's a start for a conversation. Generally, they can include any practice or intervention that has the effect of restricting the rights or freedom of movement of a person, generally with disability, but in the case of people in prison, not always, but with the primary purpose of purportedly protecting the person or others from harm. And they can include detention, seclusion, physical and chemical and mechanical restraint, as well as electronic forms of restraint, which might be tracking bracelets, camera surveillance, restrictions on people's access to electrical media devices, and other such objects. In terms of chemical restraint, which of course has had a lot of attention in recent months with both the Aged Care and the Disability Royal Commissions, chemical restraint generally refers to the use of a medication that is given primarily to control a person's behaviour rather than to treat a mental illness or physical condition. That's a simple definition anyway. And so my interest in it is how it's being used, how people's rights are being protected and preserved, and what levels of oversight and accountability we have in these systems.
Thank you, Mary. And Marlene, from your perspective, what are the contexts and environments that you're seeing?
Well, in aged care, a person with dementia may live already under environmental restraint if they live in a unit that has a keypad, so the unit door is locked, and the gardens may be enclosed, so there is an environmental restraint. Look, every person who lives with dementia will show different symptoms and behaviors in relation to their dementia. And these behaviors sort of arise from the intersection of the dementia itself, the person's life history. And for example, you may have a soldier, an ex-soldier with PTSD, and also immediate needs that the person may be unable to verbalize, because people with dementia sometimes lose that ability to say what bugs them, and that could be pain or hunger. So the ambition is to manage difficult behaviors through interventions such as identifying any unmet needs and finding ways to meet these. So, you know, give somebody pain medication, or to engage them in meaningful activities. The person may be just bored and needs something to do that gives them a sense of living a meaningful life. Reminiscing is one of these activities, but sometimes people just enjoy folding linen. But identifying an unmet need may not always be possible, and there can be really challenging behaviors, particularly if you consider that the person with dementia actually lives in a community with other people and on fairly sort of confined quarters. So there are behaviors like sexual disinhibition that probably frail elderly women would find quite confronting if a male has these behaviors. There could be agitation, and yes, these behaviors can be scary and dangerous for other residents, but also for staff. So when an aged care provider tries to make a decision, look, a number of different needs need to be balanced up against each other. So firstly, there is the collective versus the individual need, and aged care provider have to balance their residents' right to live in safety and without fear of harassment against the right of the person with dementia to live without unnecessary restraint. Secondly, the safety of staff is a serious issue when considering restraint, because providers also have to comply with workplace health and safety laws. And thirdly, resource constraints need to be considered. So on a particular day, how much staff is available, and are they skilled and confident to deal with a particular behavior that might appear? There are also factors that tend to intersect. Failures in funding often intersect with individual failures. But under the aged care funding instrument, the management of difficult behaviors pays $38 per day. And this, we can contrast this, that the delivery of complex healthcare pays $70 a day, and attending to the activities of daily living, which is showering and helping with food and so on, pays $125 per day. So for $38 per day, there is a limit how much behavior management you can fund. And in fact, many providers cross-subsidize behavior management from other income streams under the funding instrument, which is a little bit unfair, because then other older people miss out on care that they may really need. So it's a really contracted and difficult issue.
Thanks, Marlene. So already we've got quite a diversity of areas and difficulty in really understanding all of the issues and what drives some of the need from an organisational perspective, and then how to balance the individual's human rights. So thank you for the panel. Now we'll turn to Mark. And Mark's father, David, was prescribed dementia and psychiatric drugs as a resident in an aged care facility when he didn't have a diagnosis of dementia or a mental illness. And Mark noticed significant change in his father's being, which he attributed to possible medication use. And when he raised concerns with the doctors at the facility, he found it difficult to advocate for his father's rights, despite him, holding a role as an attorney under an enduring power of attorney. So, Mark, if I may bring you into this discussion here, thank you for joining us and sharing your experience. In particular, I was wondering, what did you notice were the key changes in your dad in relation to his mood and ability to communicate when he was taking this prescribed medication?
My father had a stroke where his whole left side of his body was paralysed, and he had difficulty being understood when he talked. His brain wasn't affected by it. His thought patterns were really good. But what happened was I noticed that he found it much more difficult to communicate. He complained often of really bad headaches. His hands, he started to get a tremor, almost a shake in his limbs. He was very out of it all the time. He was confused about what was going on. When you tried to reason with him, sometimes he was with it, most of the time he wasn't. And he also complained about pains in his limbs. And at the time, obviously, with his left side not moving, he did have pain for that, and we had physio coming in regularly to work with him. So it was just, he really wasn't himself. And, to the extent that I had a call from a dementia association saying that he had advanced dementia, and they'd actually been called in by the home to see him without me knowing about it. And my question to them was, who diagnosed it? At that point, they lost interest.
Okay, so there was a mismatch happening there. So you weren't initially consulted about this, clearly, by that intervention from the dementia consultant. So when you spoke to the facility and medical staff, what was their explanation for having prescribed the medication to your father?
I actually didn't get any notification of the medication being prescribed, even though I had spoken to the geriatrician after he'd seen my father and prescribed it. My father at that stage had been in the home about 9 months. So it was, he'd been there for a while. He basically, I was visiting 3 or 4 times a week, and I got reasonably concerned about how he was. So I asked for a printout of all the medication that he was on. And my father was someone who never took any sort of drugs. He grew up in the Northern Territory on missions in his early 20s, and he wouldn't even take aspirin. So he was on anything that they gave him had a maximum effect. He was on, I think, 3 different drugs. I talked to a friend of mine who was a health professional, and she had a look through and she identified a drug that she felt which was psychedelic. It was quetiapine. I didn't know anything about quetiapine, so I discussed it with Dad's doctor, and I was trying to look at whether it was the drug causing the problem or whether my father's condition had gone downhill very rapidly. And from what I'd observed, it didn't seem like it was a natural progression. So what I did was I talked with Dad's GP, who was from outside the home, and he agreed that it wouldn't hurt if I took my father off the drug for a 2-week period and stop it to see whether it would have an effect on how he was. We then talked about it, and we felt that we should talk to the home about it. So we organised to have a meeting with the management of the home and the clinical care people, and found that over a 6-week period, it just didn't happen. They kept putting me off. There was a reason this, the reason that. And the next thing I knew about it was I got a call from the geriatrician, and he'd been in to see my father, and he was quite he was very upset with me because I wanted to take my father off for a 2-week period, and he believed that I didn't have a medical qualification, so I didn't have the right to do that.
During this time, Mark, I'm just wondering, were any other alternatives to medication discussed with you or your dad?
Well, at this time, I wasn't aware of why they were giving him the medication. We had some issues with him when he was confused about things. He would lash out, And that was as a direct result of what happened to him at a previous home, where he'd been physically abused by some of the carers. So, you know, and we'd actually over that 9 months had developed quite good systems in place with me working in with the staff, where they would talk with him. They would not approach him from his deficit side. So, because I realized from his left side, if you came in at that side, you would suddenly appear. If there wasn't any progression with it. And so he would react in fright and lash out. So, you know, those strategies seem to be working. There was probably an incident every 5 to 6 weeks that the home would notify me of. And then I didn't realize that the geriatrician had actually prescribed this. It was only when I noticed over a period of probably 9-10 weeks of really seeing a major change in his personality and physical condition that I started looking at, you know, was it caused by medication, and what medication could it be? I didn't have any idea what the medication was supposed to do. If later, after I realized what it was about, it actually worked against him, because one of the things it did was make my father out of his head, so he wasn't aware of what was going on, and he was always confused. And so the behavior became worse when he was on the medication, because he was often not in his own mind to be able to do that. So what happened was, purely by chance, the next day I was in visiting my father in the afternoon on a Friday, and one of the nurses came in at 2 o'clock to give him medication, and he'd only been on, I think, 3 different medications. One at 2 he'd get at night, and 2 he'd get in the morning. And so basically, I asked her what it was, and they told me it was this particular drug. I said, well, why are you giving it to him now? And I found, and what she said was that the geriatrician had he'd gone from about 20 milligrams per day, which was at night, and they put him up to somewhere with, I think, 500 or 600 milligrams a day, which required them to give him during the day. And so at that point, I realized that I had to stand as Dad's advocate and refuse to allow him to take it, which I was told by the nurse I wasn't allowed to do. I then told her to get the head of the floor, who came down and told me that that wasn't acceptable. And I just said, I'm sorry, but if I find that you are giving it to him, I will, on behalf of my father, I'll sue you personally, and I'll sue the home. Unacceptable. And
yeah, so there was lots and lots of strong advocacy on your part that we can see, and didn't come about. There wasn't an individualised approach of understanding, say, the impact of the stroke on your father, as you said, and the awareness of various sides of his body. And I do understand from your story there was several times that you had to advocate for this medication to be ceased. And I'm just wondering, at the end of that, what did you observe when your father finally came off the medication?
Well, on the Friday, which was that day when I confronted the home and I refused on his behalf, I actually came in on the Sunday, and before I even saw my father, one of the staff members came up to me and said, I can't believe how different your father is. He was joking with me yesterday when I was doing his cares. And I went and saw him, and he was back to himself. He was joking with me. He was lucid. He wasn't shaking. He wasn't complaining of pain in his legs. It was like a totally different person. He was back to how he had been. And at that point, I realized that it was the drug, and there was no way that I would allow them to put him back on it. They went on the Monday. I had called in for a meeting with 9 of the senior staff of the home and Dad's GP, and basically the manager of the home asked me where I got my medical qualification from, and I said I don't have a medical qualification, or I'm not prescribing. I'm simply refusing the drug, as my right is as our power of attorney. And they basically told me I didn't have the right to do that, and it all went around with that particular thing. It's necessary for him. We can't deal with him without it, etc., etc. And then the last person to speak was Dad's GP, and he just said, if Mark is the power of attorney. I've got the documentation. If he doesn't want him to take it, then I'm going to not go against his will. And so that was the end of that equation. They stopped that.
Thank you. Thank you very much, Mark. I think it's really helpful for all our participants to understand what the impact is. And thank you so much for sharing that story. So I also want to go back to our panel. And can you try and explain to our audience what do you consider the constraints are in realising human rights in institutions? So if I can go back to you, Tamara.
Sure. Look, I think one of the main constraints in a prison context is just that there is less public sympathy, I suppose, for people who are in prison than there are in other closed environments. And certainly the research that I just did, I got a lot of correspondence from community members questioning why I hadn't done any research with victims and why I was defending people in prisons. And so this perception remains. And my answer to those people is always, some of these people have committed horrific crimes. Some of the people who are in solitary confinement have committed horrific crimes, but many of them have also had horrific crimes committed against them. And the rate, I run the Deaths in Custody project at UQ, and it is very rare that we come across a prisoner who has died in custody who hasn't had an experience with child sexual abuse, other forms of serious child abuse, who has not been a victim of violence in other contexts, who has not got a mental illness, who is not suffering from cognitive impairment or other disabilities. So I think there is, step one for us really is to educate the public on who it is that finds their way into prisons. And what I find in my work, and as you mentioned, I research in a lot of different areas of vulnerability, I find that it's the same people that I meet in my studies on child protection, homelessness, policing, as I do in prisons. And I think that the difficulty we have is that many vulnerable people end up in prison in situations where there were much better ways of assisting and dealing with them earlier. So I think that's the first constraint. Obviously, there are safety issues in every closed environment, and we're always concerned about the safety of staff. But what really amazed me in the last study I did on solitary confinement was the number of corrective services officers who contacted me to say that they disagreed with the use of solitary confinement, that they felt that it was cruel and inhumane, and that they were desperate for reform. So I think that shows you that staff members recognise that engaging in these sorts of practices is not necessarily ensuring the safety and security of prisons, of other prisoners, or of staff. And I assume it's the same in other contexts as well. If we respond in an appropriate therapeutic manner, we are much more likely to be able to secure individuals and facilities safety and security. Other constraints we have in a prison environment is the significant overcrowding. So before COVID, Queensland prisons were operating at 130% capacity. What that means is there is limited resources to experiment. One of the things we suggested in our study was allowing prisoners access to nature. And if we can't do that, allowing prisoners access to natural imagery. So one thing we found in our research was evidence of a program where just showing people nature imagery on a screen can de-escalate a situation that might have become violent or might have become dangerous. Massive reductions in violence just by exposing people to natural imagery. And when I put that to some of the corrective services officers that contacted me about the study, they said they thought that was a fabulous idea, but there were literally no rooms in the prison to enable that to happen. So overcrowding and under-resourcing is another huge constraint that we have in a prison environment. I suppose the third constraint that I would raise is the lack of legal and other oversight. So you've heard Mark's story and you've heard what a difference a family member's advocacy can make to a vulnerable person in a closed environment. But unfortunately, lots of prisoners are estranged from their families, and that means that they are heavily reliant on lawyers to advocate for them. Now, when they're placed in solitary confinement, their access to lawyers is greatly reduced. And so that means that no one is keeping tabs on what is going on for them. And sometimes their lawyers don't find out that they're in solitary confinement for a very long period of time and almost past the point of no return, where actually being in that environment has caused significant psychological harm, and the research suggests that putting anyone in solitary confinement can very quickly cause psychological deterioration that may be irreversible. So in situations where there is no external oversight, then we are essentially making a potentially dangerous situation much worse by putting people in situations where they are experiencing psychological harm, where they become angrier, where they become less able to then reintegrate into the community later on. Related to that is the lack of legal oversight. The courts very rarely intervene in decisions like this because they tend to leave it to prison authorities to make decisions about prisoner management and facility management. That means that our capacity to make a difference with the legal system is also drastically reduced. So there are lots of special difficulties in prisons, but I think there is a significant amount of overlap too with some of the other closed environments we've been talking about.
Thanks, Tamara. And just to look at where some of the overlaps might be, Mary, if you'd like to talk about the constraints you see.
Speaking of overlaps, I also have a background of working in prisons, and just as a postscript to what Tamara was outlining there was a deliberate decision in the amendments to the corrective services legislation in the early 2000s to remove prisoners' rights to bring judicial review applications of decisions like this that would put them into solitary confinement. So there was a conscious government policy decision to remove that kind of oversight that would protect people and hold systems to account. And that was a very disappointing thing. Even back in the days of Boggo Road, we had that, but we didn't have it. We don't have it in the 21st century. So that is something that we really should be looking at addressing and reforming. But in other spaces, and in particularly in aged care or facilities, look, we're talking about institutional settings here. So I think the biggest problem with trying to realise human rights in those spaces is that institutions sort of run their own way. And when we talk about institutionalisation, it's a term that does go across, prisons, nursing homes, disability facilities, because they sort of almost just run automatically somehow with these various processes and procedures that everyone sticks to. So that becomes a real obstacle. And I think Mark really outlined this. What often happens is that the facility wants one outcome or thinks this is the outcome they're wanting to achieve here with this person, when in fact the person or their supporters want something different, and that's when things start to go wrong. And often it starts with a sort of a misunderstanding or a miscommunication, and what they really want is for people to be safe, but in fact it translates to, well, we want them to stay in bed and be a bit quiet, and then we have people being given medication. Or we might have an incident where your father lashed out and the staff get a bit frightened. And institutions, employers have responsibilities to protect their staff as well. And so they're in a bit of a bind working between the two. So that's part of the problem. I think it's also really important to recognise the other point that Tamara made, particularly, and I think it applies in the context of aged care as well. No one really goes to work to do a bad job in these places. I feel sorry for people who have been working in the aged care sector and in the disability sector who really like their work and care about their clients, and who are hearing these terrible stories every day and feel quite tainted by it. And so, but what happens is when you work in institutions which are underfunded and who are focused on certain end goals rather than the people that they're meant to be serving or servicing, you get this disconnect, and you get, they just grind people through. And so you get this brutalising not only of the residents, but of the staff as well. Because when these things are happening to people who are being abused or being neglected or not getting the sort of care or stimulation that they should, the staff they know this in their hearts, and so they actually are become damaged in a way as well by it. Some more seriously, and others just feeling as though they're not doing a good job and they're not contributing to something that's good in the bigger sense of things. But I think some of the big constraints and these are sort of very subtle, but the sort of on the ground kinds of constraints to what's, to realising people's human rights. But it comes down to money. It comes down to proper funding and resourcing, and governments and politicians having the will and caring enough for like children and families where you've got children who need support and families who need support to do better, children who end up in detention, people and ultimately in prison. And all of these institutions and systems are underfunded so that no one ever really comes out better. They come out bruised and battered by it, and then finally we'll all get older and we shove it in another place that we're not funding very well. And so what it really is about is we as a community need to say this stuff really matters because it's part of everyone's life course in a way. And if we were doing it better from the beginning, we'd all have more money to spend on a whole lot of other things, because we wouldn't be spending it on prisons, and we wouldn't be spending it locking people in disability facilities, but we would be doing more to empower people to live more productive lives. So I think, unfortunately, it does come down to money. And when it comes down to money and you have fewer staff and they can't spread themselves far enough, and solitary confinement is used as much in prisons for that reason, I think, as well as people being locked in the rooms in detention, in dementia units for the same kinds of reasons. But we need to, and then what ends up happening is those things get framed within policies to justify it. So it's for safety in prison.
That's right. And
so they create these explanations or justifications for it. And in aged care, it's because we're trying to keep the people safe.
Yeah. And you get very much balanced into the risk management framework, yes, rather than looking at a human rights or economy.
And it's very hard for people who don't know the data and the figures and the facts to counter that. If you've got people who are experts in care telling you that your father needs to be drugged because otherwise he'll fall over, or he'll wander about and might fall over, and we know, those who know that's not right, and I know Marlene doesn't think that, but it is often told to people, and it's often the justification for the administration of the medication, and when in fact it increases those risks.
Thanks, Mary. I might just bring Marlene in now to talk about the constraints that you notice, Marlene, in making sure people can realise their rights.
Certainly, yes, institutionalization is a really important aspect. And I think whenever a place is very tightly funded, then, making ends meet will easily override other considerations, because, in the end, you have a balance sheet and you either go broke or you survive. So there are really tangible outcomes, more tangible than somebody's human rights. So that would be one factor. But I think, look, clinical practices also get institutionalized, and people who work with clinical practice change know how difficult it is and how many years it takes to implement a new clinical practice. It takes a lot of effort. It takes a lot of evidence, and aged care is sadly an evidence-free environment because, look, there hasn't been much research interest. There hasn't been research activity funded to look at the care of frail aged people. So we are missing the evidence. It's very patchy, and I think you probably also see the outcome there of an institutionalized sort of ageist approach by governments and society, and dementia would really fall into it because it's really a mental health condition in a way. It affects the brain, so you can just see how society's priorities drop down because you know, these people are not active in the economy, they have a mental health condition, they are old. Yeah, so that would be one aspect where you know, a lack of momentum and drive would arise from you know, a way of thinking in society, in politics, to explain why there hasn't been enough practice improvement in this area. There are actually only now, the government only now has funded the development of clinical guidelines for GPs to prescribe antipsychotic medications for frail elderly people. That is underway now. And it's really sad to think it hasn't been underway 10 years ago because, you know.
Yeah, that's quite amazing. And whilst we're on chemical restraint, given that's a great example that Mark's given us earlier, how do you propose, besides the clinical guidelines and the improved clinical practice that you speak about, how else should chemical restraint be regulated, Marlene?
Look, I think if just the consent laws were observed, and that, you know, we have now discovered with the Royal Commission that doctors don't always seek consent for these medications, but as prescribers, they are really they have the primary responsibility. Aged care providers would have some sort of secondary responsibility to protect their residents from unlawful act, and prescribing a medication without consent is an unlawful act. I think if just that was implemented, I think we would see some improvement. We really would like to see funding for practice improvement programs for training staff in the management of difficult behaviors, to have more staff and to provide the funding. But funding in itself won't do it. There needs to be a culture change as well. And culture change just won't happen with the money coming through. There need to be added activities on a policy level that then translate into practice change in the care setting.
Thanks, Marlene. And Mary, did you have any other comments or thoughts about how chemical restraint should be regulated in aged care?
Marlene hit on it. My number one was better education and, I suppose, accountability around patients, informed consent from patients or from their legal decision makers. And I think doctors either don't understand this or choose to ignore it. Certainly in Mark's case, that appeared to be what was happening, and more than once with more than one doctor, it seemed. So I think that's the major concern here, is that doctors are actually not fulfilling their professional responsibilities, and we have to do something about that. But I think when you are prescribing medication for a person's behaviour rather than a medical condition, it requires some level of recording, reporting, accountability and oversight, and it should be reviewed within a reasonable time, part of a larger restrictive practice framework.
Okay, thanks, Mary. In the time that we've got left, maybe Tamara, if I could get you to comment on what you've observed within institutions is with COVID-19 responses, and whether you think, you know, whether you observed extension of the use of solitary confinement, and whether you consider that's been proportional.
COVID came at an interesting time for Queensland, didn't it? Because it was an immediate challenge to our new human rights framework. And so we were thrust into this space where we had to very quickly determine what proportionality was, you know, under what circumstances are we allowed to restrict people's human rights. And I think what we found in prison context is that the legislation we had, which is completely inadequate, even then wasn't followed and wasn't enough to secure really basic rights. So even the WHO said that people in closed environments may well need to be placed in medical isolation, but this should only be done as a last resort, and it should be done in a way that is respectful of people's human rights. And yet what we saw in Queensland was people being unlawfully locked down for 24 hours with no out of cell time, even though the regulations say that the minimum amount of time someone should be offered exercise is 2 hours. That just simply wasn't happening. And another aspect of the regulations is that people should have access to a toilet, to water. Even that wasn't happening. People's toilet flushes were limited during COVID. They often didn't have access to water and food. They often didn't have access to their friends, family at all for extended periods of time. So we really did see very quickly that when we start locking people down and restricting their human rights, we're not very good at asking ourselves whether there was a less restrictive alternative. And in situations, in prison context, there were definitely less restrictive alternatives. We have access to technology. People could have been provided with the cordless phones, the iPads and the video calls that they later got right at the start. We all use these things every day. People could have had access to medical support and counsellors. We know how important that is, and yet that wasn't happening. So even the limited law that we had to protect people was ignored, as has been said here. If in closed environments we can't rely on staff to follow the legislation that exists, then we're automatically on the back foot, aren't we? And it means that human rights are being trampled on, and we don't necessarily know about it. And we're very limited in what we can do to prevent it.
Thanks, Tamara. Mary, I might just ask you, what else you've observed during the COVID restrictions, and then also ask you to help us wind up and what practical next steps you'd like to see.
Well, look, in the aged care space, it's very hard, as you were saying, Tamara, to actually tell how restricted people's lives are, because if you can't get in, you can't see what's going on. That said, though, I think that after what we saw with the risks and the outcomes in New South Wales and Victoria, I think you'd be hard pressed to say that restricting people's visits to nursing homes was a breach of someone's human rights, the residents' human rights. And I suppose in those cases, like no one asks prisoners what they'd like, but I'd be really interested to, after this blows over, to ask residents of aged care facilities how they felt about the measures. They might have felt really protected. And I think there is a real balancing act here. So, and I didn't hear from many people. There was a lot of sort of talk generally in the media, but not much came to our office. And certainly it wasn't necessarily coming up through other areas. We were concerned about people not getting access to their usual health services and other sort of allied health supports to keep people well. That's a big risk for in the disability and the aged care space when these things happen. What does worry me, though, is there is a sense like if it's an institution, you lock it down, and that applies for prisons, hospitals. People couldn't get into hospitals when they were sick, and they were discharging people madly, and the same with aged care. And so there is, and the general public goes, well, we don't know how to run them, so they must know what they're doing, and there isn't much of a question about that. So I think it probably wasn't as bad. We did see decisions, though. There was legislation passed to allow the locking of gates, doors and windows in disability accommodation. And there was some legislation passed to completely stop all visits in and visits out of the Forensic Disability Service. And we actually couldn't really see any justification for either of those. And certainly informed the government of that. And to the government's credit, they've not extended those provisions past the 31st of December. So we're relieved to see that. I think they realised it might well have been a bit of an overreaction. We were the only state to do something like that. And that was very disappointing. That was in the discipline.
That's good to hear that. And then looking to the future, Mary, what are your top...
I'll talk very quickly so everyone else gets a word. Advocacy services to help people understand their rights and to be supported to enforce them, at least to air them. A uniform restrictive practice framework that could operate across disability, aged care, hospital services, and also mental health services. You'd have consistent approaches and frameworks and guiding principles, and also particularly in the aged care space, revisiting the legislation and drafting it with based on human rights principles, and certainly in the prison space, reintroducing the rights of prisoners to seek review of administrative decisions.
Excellent. Thank you, Mary. Mark, I might just ask you, what would you like to see change moving forward to improve human rights responses?
I think I agree with the need for advocacy, because for me, when things got to a point where they were trying to have me removed as the dad's guardian because they didn't agree with what I was doing, that I got involved with ADA, and they were brilliant. I mean, and they did nothing but delay the home until they gave it up. So, but also they were good in talking about what the rights were and supporting. I think the second thing is that there needs to be some, I never had a real issue with the staff on the floor. It was always the battle was with the management, who were looking at saving money. And of course, money is always the issue. And I think possibly that something around floor staff ratios to different clients would be something that would probably improve. Because I know that what happened was that they slashed about a third of the floor staff, and it had a serious impact on their time to do anything.
Okay, thank you. They're really good suggestions. Marlene,
well,
what would you like to see?
We would like to see funding for more and better skilled staff, and funding that enables the education of staff, so further education, and that would need to involve also, if somebody is undergoing training, the needs of the older people are still there, so we need some funding for backfilling. We would love to see more research to actually identify the best models of care and best practice, because we don't have that at this point. This has not been done, and it would really help the sector because then we would know where to improve to. At the moment, we don't really have that. That would be really helpful. Look, we would love to see a change in politics and see the general community get more engaged in the issue of aged care, but it seems to be a scary topic. I think everybody is fearful of needing aged care themselves, and so it's blocked out. It's sort of maybe a sign of the ageism in our society, but if we had the community behind us, it would really help us to get the political momentum going and to get the politicians interested.
Thank you, Marlene. And Tamara, could you talk about what you'd like to see in the next steps to improve moving towards a more human rights focused?
I think I'd echo, a lot of what's been said. I think that human rights training is really important. I think the thing about human rights is they don't mean very much if you can't enforce them. And unfortunately, human rights is actually a really complex area of law. So I think we do need lawyers to be very well trained in how we can use human rights law to bring about changes in these kinds of environments in particular. I think that we need to be educating our frontline workers also on human rights and human rights standards and what they can do within the bounds of their powers and responsibilities to implement human rights. And that's something that I did have corrective services contact me and ask about, what action they could take. I think research on de-escalation strategies is so important. When we went looking for alternatives to solitary confinement, we had to dig deep. There's very little research out there on what we can do instead. And in fact, Heather Douglas and I did a study on adolescent family violence, and we heard exactly the same thing from parents and from lawyers representing parents. Even for children, there is no good advice on what we can do to de-escalate situations, to make children feel safe, and also to appropriately manage behaviour so that everyone in the home or institution is safe as well. So I think we need to improve our knowledge. I think we need to be armed with the right legal tools, but we also need to be armed with the right practical tools so that we can see a difference made. I think we do need more funding to implement the strategies that we've talked about in order to prevent the ripple effects that we see happen when we don't protect people's human rights and treat them with what is, I think, the most important human right, dignity and respect. In many situations, just by treating people with dignity and respect, we necessarily are making a difference to the realisation of other human rights. But our legal services are so stretched, and watching Prisoners Legal Service trying to deal with all of the inquiries and difficulties that happened during COVID, it was made very plain to those of us who work with them that, you know, 1, 2, 3 staff members in these organisations is simply not enough. So there's lots we can do, and let's hope that now with our new act, we start seeing some change.
Fabulous. And thank you, Tamara. That's a great way to finish. And thank you for all the suggestions of our panellists. So I'm sure our participants would find that we've had a very rich and rewarding discussion tonight, and really thank Tamara, Mary, Mark and Marlene for bringing all these ideas, practical, broad and really helpful suggestions, bringing them to the fore in our discussion. So thank you very much. Thank you very much for your time and effort. Good night.
Thank you.
Thanks.